Thank you for joining this video, this live webinar on Facebook Live. As you might know, my name is Mohammed Abduroaf. I'm a practicing advocate in Cape Town, and part of my specialty is family law. I on a regular basis deal with issues concerning child custody, child maintenance, divorces, and the peripherals thereof. I might be called upon occasionally to deal with an application regarding relocation of a minor child, or where parties cannot agree upon a minor child obtaining a passport, and so on. Today's topic, child maintenance questions part 2. The drill is as follows. You can post questions, live questions, and I'll try my best to answer it for you. The Facebook Live page that we'll be using would be the Advocate Mohammed Abduroaf page. So it's on facebook.com/ADV Mohammed Abduroaf/live. You should be able to see it on your screen. We have created a redirect link. If you type in www.abduroaf.co.za/live, it should redirect you to the correct link. Therefore, feel free to partake in this webinar. Sometimes we get questions, sometimes we do not. Sometimes people prefer to listen and learn. If you are watching this video and you find it useful, please feel free to share it. Someone might find it useful. While we're waiting for people to post questions, I will discuss one aspect regarding child maintenance, which is very relevant. It is an issue concerning international child maintenance, whereby one parent will reside in South Africa and the other parent in another country. I'll just lightly touch on this topic. It might apply to you, it might not apply to you. If if you require child maintenance and you reside in South Africa and the other parent resides in another country, depending upon the country, it is possible for you to obtain maintenance from that specific person. The usual manner in which the Maintenance Act works is, or the maintenance process works in South Africa, is based upon the fact that you live in South Africa and the party from whom you're claiming child maintenance also lives in South Africa. Our laws only applies to South Africa. We can't make laws that is applicable to another country. Each country is sovereign. They are regulated by their own laws, their own rules, and one country cannot tell another country how to do its job. And also, we cannot tell other citizens in a different country what to do. However, countries have agreements in place. For example, extradition, where somebody committed a crime and one country can request that specific person to be returned. But you cannot make an order in South Africa stipulating you must return from another country. That just won't work. Therefore, in regard to child maintenance, the same principle generally applies. We have to apply for international child maintenance via diplomatic channels. The long and the short of it, you approach your local maintenance court where you reside. You make an application for child maintenance in terms of the REMO Act, Reciprocal Enforcement of Maintenance Orders Act. You make the application, you approach a maintenance court, you tell them the father lives in a different country, you stipulate the country, let's say the United States, and you have his details, you know where he is, and you'd like to claim maintenance from him for your child. You start the process, you make the application, the local maintenance court will obtain evidence, ask you questions, verify what you require, and so on, and they'll make a provisional order. That specific order would be sent through diplomatic channels to the country where the other party resides. And I'll pause here for 1 second. It's important to note that South Africa does not have an agreement with all countries in the world. For argument's sake, let's say Saudi Arabia, we do not have a reciprocal enforcement of maintenance agreement for them. Therefore, if you want to claim maintenance from them, you cannot make use of the Reno Act, which is a South African act. You will have to find other means of obtaining maintenance should the person reside there. Maybe look at the possibility of obtaining a lawyer that works in Saudi Arabia, in this example, and he might have laws applicable there that could assist you. And each country will have their own rules and regulations. That's my experience regarding international maintenance law. So let us presume South Africa has an agreement with that specific country from where you like to claim maintenance from the specific parent. You file the application, the court makes a provisional order. Through diplomatic channels, it sends the documentation down to the person, the designated department or person in the other country. It could be the Office of the Family Advocate, for example, or the State Department, or the local magistrate, whatever the case may be. Once the receiving country obtains the documentation, they will themselves do an investigation, call the other party in, and inquire as to firstly whether or not there is a legal obligation to maintain the minor child. He or she might dispute paternity or maternity. There might be an issue regarding the amount, whereby in South Africa you're claiming quite an exorbitant amount and the other party cannot afford it. There might be disputes regarding the actual claim itself, whether or not it's reasonable or not. The receiving country or the foreign country will do the necessary investigations, the inquiries, and so on. And once that is now finalized, they will make an order. And if that order is, that specific order, details thereof will be sent down to South Africa and will be a binding order. Therefore, if the foreign country, the person, the resident there, does not pay, he or she will be committing a criminal offense. The reciprocal also applies in the sense that if you live in South Africa and the parent lives overseas, let us say for this example, the mother resides overseas and the father lives in South Africa, and she would like to claim maintenance from South Africa. For example, a state in the United States, that's where the mother resides. We have an agreement with South Africa. The mother will apply in that state. I think California applies. And she will obtain her provisional order, which will be sent via diplomatic channels to South Africa, and it will land up in the maintenance court, the relevant maintenance court, where the party resides. The maintenance court will call this person in. So, for example, if the father living in South Africa, he lives, for example, in Cape Town, he will be called to the Cape Town Maintenance Court, advised about the process, what's happening. An inquiry will take place regarding his financial circumstances. And if we in South Africa can determine those issues I mentioned earlier on, he can afford the maintenance, he is the father, and the amounts are reasonable, etc. And then the South African court will make a maintenance order. And it will be enforceable. If the father does not pay the maintenance, he's committing a criminal offense. That's the long and short of it of international maintenance law. I thought I'd bring it up because I'm dealing with a matter like that at present, and you might find it relevant and useful. If you have any questions regarding child maintenance, please feel free to post it. We've decided to do these videos a bit later, sometimes earlier, so many people can benefit and learn from it. Moving on. When it comes to the issue concerning child maintenance, there seems to be a problem, or a perception rather, that you should pay child maintenance equally, 50-50. That's how they say it. If the mother earns, let us say, use round figures, 1,000 rand per month, and the father earns 10,000 rand per month, there seems to be a perception that the mother should pay half the minor child's expenditure, which might be, let's say, 400 rand per month. She should pay 200 rand per month, and the father should pay 200 rand per month, despite the father earning 10 times the salary. That is not the law, and if magistrates and if courts are applying that principle, they're not applying the law correctly. You are obliged to pay child maintenance according to your means. You're not obliged to pay child maintenance 50-50, half-half. That is not the law. So that's very important to note. If someone tells you otherwise, they're not speaking to you correctly. If the mother tomorrow earns more than the father earns 10,000 and she earns now 100,000, then her obligation increases. Then she must pay 90% of the child maintenance and the father pay 10%. Another query which I got today, and I think it's relevant as well. The parties, they entered into a consent paper or a settlement agreement. The same can apply with regard to a maintenance order in a maintenance court, whereby the consent paper or the agreement stipulates the following: that maintenance will be paid for the minor child until such time he or she becomes self-supporting or attains the age of majority, being 18, whichever happens first. Now, it's a complicated clause, but it happens all the time. Basically, what it's saying is that the party is only obliged to pay child maintenance in terms of the order until such time the child can maintain his or herself, like it's a job and works and have an income, or he turns 18, whatever happens first. So if he gets a job and can work and so on at the age of 16 or 17, then the maintenance obligation will fall away in terms of that clause. Or he turns 18, then the maintenance order falls away. It is a bit problematic because whatever happens first, it means that the maintenance order will remain in place until for the maximum when the child turns 18 years old, which is not a good idea. I wouldn't advise you to sign such an agreement. Maybe say 21 years old, or maybe say 24 years old, but I do not say 18 years old. But if that is the case, the maintenance order will basically fall away, but the obligation doesn't fall away. That's very important to note. Obviously, the minor child becomes self-supporting at the age of 17. Then the maintenance order can fall away because he or she is self-supporting. But if he is not self-supporting at the age of 18 and still being maintained by the primary caregiver or lives with his mother, although he's an adult, it would be unfair for the maintenance order to disappear, and what it entails is that he should apply to the maintenance court for maintenance court against his father or the other party. If an agreement does stipulate those clauses, remember it disappears at the time, for the latest, at the age of 18, and if that does happen, that specific child needs to approach the maintenance court for a maintenance order afresh. That's the one or two queries I'm dealing with today, and I thought I'll bring it to your attention. It's something which many people ask quite regularly. It does come to our desk every now and again. Another question that gets posed is, I do not have income, but I have assets. I lost my job, but I own a house. The house is bonded, and I have some other things. Do I still have to pay maintenance although I lost my income, but the other party has an income but not assets? It's a bit of a tricky scenario to deal with, because when dealing with child maintenance, we do not only look at your income. That will be improper, it will be incorrect to only do that. We have to look at your means as well. We look at your assets, what value you have. That is how we determine what's a fair amount of maintenance to pay. Some courts only look at your income and they do not look at your assets, which is improper, which is incorrect. I therefore implore you, should you find yourself in a maintenance battle with the maintenance courts of applying improper principles, legal principles, to please consider appealing those specific decisions. It's not correctly made and it needs to be challenged. And there are these many laws applicable, there's many resources available in determining how maintenance amounts are calculated. You can Google it as well. Google South African law on child maintenance, how much you are paid, case law on child maintenance, How does the court look at aspects regarding assets and income? So you'll find some authority regarding that. The maintenance court has to consider all facts. Therefore, if the mother earns 5,000 rand per month, she could have taken out a bond, I purchased a house and take out a bond, and maybe 3,000, I'm using round figures here, would be used towards the house. And she can acquire an asset. But she cannot do that because she has to pay or support a minor child. Then we have the scenario where, in the same scenario, the father earns double what the mother earns. But then he uses half his salary to pay off a bond and to empower and enrich himself. It cannot be said that that's a fair scenario, because if the mother is using all her money to care for the minor child, the father should obviously use his assets which he has built up over time to also maintain the minor child. It's my view that is fair. Therefore, remember, regarding child maintenance matters, parties will have to look at your assets and your income. We have to look at your liability as well. But it's very important to consider, to not forget about the fact that assets are relevant in determining the maintenance amount a party must pay. Then we get this scenario, the type of question where people pose, I pay child maintenance, I pay for everything, but the court ordered that I can only see the minor child once every second weekend. So maybe on a Friday night or Saturday night. That is a question that gets posed many times, and when people consult with me, they quick to mention, which they're entitled to do, they're quick to mention, and I think it's relevant at least, that I'm paying child maintenance, I'm paying for this, I'm paying for that, but the mother refuses me contact. A parent should not refuse another parent contact to the minor child unreasonably. So that is something which I need to put out there. The question I will need to, the issue which I have is whereby people believe that if I pay more child support, or if I pay for all the minor child's needs, automatically by default, I'm entitled to have more contact rights to the minor child. That doesn't go hand in hand. Child maintenance and contact rights are two separate issues. Obviously, a parent that pays adequate child maintenance and wants to form part of the child life should get that opportunity to do so. And if there's a dispute, the matter must go to mediation or to court, and the court will make a fair decision. And at the same time, we do not want a scenario where parents say, where mothers say, Dad, pay more maintenance, you can see your child more. That's nonsense. If your father is entitled to see the child more, he should not be affected based upon the fact of how much maintenance he pays. The taking home comment would be maintenance and maintenance and custody issues are two separate issues. We need to look what is best for the minor child. Therefore, it is possible to have a scenario where a parent pays no child maintenance at all, nothing, but he or she sees a minor child every weekend and half the school holidays, despite paying no child maintenance, because that parent cannot afford to pay the child maintenance. The other parent maybe earns much more money. Whatever the facts are, that's just a hypothetical example, but it is possible. And alternatively, the argument could be the parent pays no child maintenance at all, but he or she saves up the money to care for the minor child during the Pacific weekends, alternatively during half the school holidays. Child custody issues and child maintenance issues are separate issues. Thank you. Moving on, I see no questions. If you have any questions, feel free to pose it. What generally happens is when I end these videos and I go on Facebook later the evening or the next day, I see many notifications where people pose questions and watch this video later on. Unfortunately, we cannot answer those questions later. We will try to do something to that effect, but it is too cumbersome because sometimes we have to ask a question in order to properly answer. And we do videos about 3 or 4 a week, and in a month's time it's about, let's say, at least 15 videos, and you can't follow up on each one of them. It's too cumbersome and time consuming. However, please, if you have any questions now, please pose it. We will be online for the next 10 more minutes. These videos are about a half an hour long. Moving on the issue concerning child maintenance, part 2. If a parent wants to pay child maintenance, However, the other parent says, I do not want your money at all. You can see the child, but I do not want any child maintenance from you. You can't approach a maintenance court because the maintenance court basically is there to enforce the payment of maintenance. There has to be a complainant and a respondent. If you go to the maintenance court and say, I would like to pay the mother money, the court can look into the matter and say, ma'am, you must take the money. It's a bit of an issue, so it won't really work. You can't force someone to take maintenance. You can maybe obtain a court order stipulating that you should pay certain other minor child expenditure. So if the child attends school, you approach a maintenance court and say, I want to support this minor child. The mother does not want to let me pay for it. Therefore, I would like to pay for the child's school fees. Please make an order in that effect. I never saw something like that before, but I'm certain the maintenance court can maybe come to your assistance regarding something like that. However, there's not much you can do, but this is alternative. The alternative would be open up a policy, put the money into saving. It's very important that you do something, because remember, you have a legal obligation to maintain the child. And if the other party is refusing to obtain assistance or obtain maintenance from you, save that money. If it's 1,000 rand you can afford per month, put that 1,000 rand away. It will turn into 12,000 for the year, and it will grow accordingly. So once the tide change, where the other party is struggling financially, or he or she now decides to claim maintenance, you would have saved up a lot of money, and you would be able to pay maybe for the child's tertiary education and so on. Yes, I received a comment over here. Please let us know in advance when you're going to live so we can have time to log on and ask questions. No, thank you for that. Thank you very much. The challenge we have is it's difficult to specifically stipulate what time you go live. And I know it's pragmatically an issue because you'd like to pose a question and you're wondering, when is this advocate coming online? Sometimes I do it in the morning because I'm available, but the next morning I get an inquiry, I have to draft some documentation, I have to attend court and so on. And the time is a bit challenging. The only times which we generally guarantee are those live Zoom webinars where people can register and log in, and I make sure I have no court appearances or any consultation at that specific time. But thank you for that comment, and I think I should do something. I think we should give a bit of notice, at least the morning, stipulating that we're going live this evening. So I thank you for that, and I will work on that. But if you have any questions, please feel free to pose it. I'll be happy to answer it for you. Therefore, going back to our previous question, if the other party does not want to receive child maintenance, put the money in a policy, save up the money, keep a record thereof, and when the time comes, the money is there for the minor child. Let's say, for example, with this lockdown, it would have been very useful to you. Moving on to something very interesting. The person said, thanks, you are welcome. Something very interesting regarding child maintenance is the issue concerning, what do I do if the parent who is supposed to pay child maintenance truly cannot afford to pay child maintenance, but I require child maintenance? Then we have to look at other options. You may proceed against his or her parents. Luckily, I was involved in a case many years ago, the Peterson versus the Maintenance Magistrate of Simonstown Court, where the Western Cape High Court declared that paternal grandparents had the same legal obligation to maintain the grandchildren as maternal grandparents. That specific case, the law at the time stipulated that you may only claim child maintenance from the maternal grandparents, meaning the girl could only go to her parents and claim maintenance for the child that was born out of wedlock. My apologies, we're dealing with a child out of wedlock. In wedlock, you could have approached any grandparent. Then the Peterson case came along, and then the court made an order that there's no discrimination between children born within wedlock and out of wedlock. You can claim against grandparents from both sides. I'm not going too much into technicality as to how the process works. When can you go against one grandparent or not the other grandparent? The bottom line is there is an avenue available. Therefore, if the fathers, in this example, his parents are quite well off, they have some money available, or they're earning well. Let's say the father is a student, he's quite young, he is unemployed for whatever reasons. Child maintenance must be paid, the child must eat. Under those circumstances, you may approach the maintenance court and lay a claim against the paternal grandparents for child maintenance, despite the child being born out of wedlock. But it doesn't matter really. We can apply also to parties who are married. You are welcome to approach the maintenance court and say, my child requires child maintenance, the father cannot afford, he doesn't want to pay is not a good answer. The issue is he cannot afford to pay. We will hamper the father until such time it's confirmed that he cannot afford to pay. If the father can afford to pay, you cannot go against the grandparents and say, oh, they need to enjoy their lives. They've done their job. They pay their maintenance. They maintain their child. However, if the father truly cannot afford, and there might be many reasons for that, the grandparents should step in and make a contribution towards the child's maintenance. That's very important to note. I think we're running out of time. Thank you very much for partaking in this webinar. The specific commenter, yes, I think we should do something to that effect. Every morning, just put out a notice and people can prepare the questions and I'll try my best to answer that. Thank you for partaking. I hope you have a wonderful Monday. Many people are starting work. Unfortunately, schools are opening a bit later, or fortunately, depends how you want to look at it. If your mom at home stressed out and the children are just working on her nerves, unfortunately, but for the COVID-19, it may be said it's fortunate. Be that as it may, whatever the reasons are for that, please note that the holidays are now being extended. Meaning that custody agreement, maintenance agreements in the past used to consider the fact that school holidays are for so many weeks, 6 weeks and so on. Here all of a sudden the school holidays are extremely long. This is now going to be the longest December holidays ever that minor children have experienced in recent times. The custodian parent would be spending more money on the minor child. Please increase your contribution if possible. Minor children eat much more during school holidays. They also require more entertainment, whatever the case may be. They do cost more, so please increase your contribution. And if you feel that you should obtain a better contribution from the other party and he or she is not coming to the table, please voice your concern, voice your grievance, my apologies. Go to the maintenance courts if the other party is not being reasonable. Regarding care and contact, please, parenting plans and consent papers would generally say the December holidays would be divided as follows. Cut it in the middle, because we knew more or less how long school holidays would be. We did not expect the school holiday to be extended for so long, by another 2 weeks. Therefore, please be reasonable. Try to share the minor children as best as possible. Do not force the other party to approach the courts. Things will have to be re-looked at currently. So if you feel that you are being unreasonably treated, that during the December holidays, December and January holidays, you only obtain contact and care rights in terms of a custody order, which was most probably for 2 or 3 weeks, but they should have obtained contact and care for about 4 or 5 weeks, whatever the case may be. And going forward, this parent is being unreasonable, please consider approaching the children's court or get an attorney to approach a high court, or you can approach a high court yourself if you know what you're doing, and do something about it. It will be in the minor child's best interest. We are living in uncertain times, and at the same time, parents need to work together in order to make the minor children's lives as best as possible, and at least when it comes to parents' rights to the minor child and the minor child's rights to have both their parents in their lives. Thank you very much once again, and have a lovely evening, and we'll see each other soon.